The Assistant General Manager versus Akileshwari Devi for the appellant
May
Sri
please, your
Rakesh
Lord.
Kumar Singh.
My Lord, in the case, my Lord, the last order may be seen, my
Matter
Lord.
is covered, sir. Covered by the
Just,
latest.
just I'm coming, my Lord. The last order is that, my Lord, the prima facie, the appellant had not made out a case for a simple reason that the respondent number one, who is the wife of late Ram Nandan Prasad, who was an employee of the appellant's bank. My Lord, the petitioner husband was not an employee of the bank, my Lord. He is the employee of the Government of India, Coal Wings, Ministry of Mines, my Lord, as has been stated in paragraph 3 of the writ applications, my
Then
Lord.
who has taken action for recovery?
My Lord, what happened in this case, my Lord,
Who has taken recovery action?
due to the miscalculation, my Lord,
Mr. Counsel, please.
bank, my Lord.
Bank.
Bank,
So
my Lord.
bank.
So, my Lord, not a employee. This is the this.
Maybe. Then why did you, if he is not your employee, why did you initiate proceedings? Recovery proceedings?
Recovery proceeding is that, my Lord, what happened in this case when the data was transferred from branch to CPPC centralized pension units, my Lord, there is two columns.
Sir, you have to suffer, that's all.
Just, my Lord, there are two columns, pension columns and family pension column. At the time of transfer of data, my Lord, the family pension has not been ticked, only pension was ticked there, my Lord. So, my Lord, the Lordship has also stated, my Lord, the last chance. My Lord, the writ application is not maintainable first of jurisdictional error, my Lord, because he has to approach to the CAT, my Lord. As your Lordship also had in
Anyway, he has questioned the bank.
my Lord,
He has questioned the bank action.
my Lord,
Bank in respect of against any direction or action of the bank,
Yes,
he has to approach this court only.
no, my Lord,
If the government of India has taken any action against him
Yes.
or her in respect of recovery, then she has to approach CAT.
first thing, my Lord. The second thing, my Lord, my Lord, the Rafiq Mashi case which has been cited,
No,
my Lord.
not Rafiq. We are in the latest case,
Yes,
Daniel
ma'am.
Thomas.
Yes, my Lord. Yes.
Daniel Thomas.
Yes, my Lord. Just I have also this, my Lord,
Uh,
judgment, my Lord.
you are citing Daniel Thomas.
Yes, my Lord. I am just giving the Thomas case, my Lord. What happened in this case? In this case, my Lord, this is the case between employer and employee, my Lord.
Uh,
My Lord, the wrong increment has been calculated, my Lord.
Whatever.
That was given in that, my Lord. In here, my Lord, also the case of the Jagdev Singh, my Lord. I have also citing the Supreme Court judgment, my Lord.
huh?
Supreme Court judgment, my Lord. In this case, with regard to the Jagdev Singh case, my Lord, also reported to 1614.
Jail Singh case.
Jagdev Singh case, my Lord, High Court of Punjab and Haryana, and Jagdev Singh case, my Lord. Just a minute.
Sir, principle is whether recovery after after payment of excess amount, can it be recovered or not? That's all.
My humble
That is the
submission is that, my
principle.
Lord, this is the not a case of
Yes,
the
we will
recovery.
consider.
This is the case of recovery due to mistakes, my Lord.
All right. Yes.
My
That's
Lord,
all.
my Lord, if you Lordship consider, my Lord, the case of Rafiq Masih, my Lord, before that the Rafiq Masih was referred to the larger bench, my Lord. The judgment which
Sir,
I-
Rafiq Masai is in respect of Group C and Group D.
Yes, my Lord.
We are not concerned with that.
No, my Lord, the proposition is that, my Lord, the Justice Qadir judgment relied on the Sahib case, my Lord. Just time, my Lordship.
Sir, all those things are diluted in the Daniel case.
Yes, just my Lord. In the, my Lord, this judgment was based on the judgment of the Sahib Ram case, my Lord. In the three judge bench of the Supreme Court say, my Lord, the Sahib Ram case is the passed under the order under Article 142, that is not binding. Binding is that, my Lord, the case of Chandi Prasad Unial, that is reported in, my Lord, 2012 volume 8 SEC, my Lord. Maybe look into that, my Lord.
We'll deal only with the Rafiq Masai and this Daniel Thomas.
Yes, my Lord.
This is the latest decision. We will follow this.
No, my Lord,
Supreme Court has also.
the fact is different. The fact is Supreme
All
Court.
right, I will consider.
Yes, my Lord.
Your fact is that there was error on the part of the bank.
My Lord, the error due to mistakes, my Lord, due to typographical, any payment made by the mistakes cover under the section
And
72 of the Contract
What
Act,
was the
my Lord.
time taken by the bank to
Rectify it.
detect the error?
Yes, my Lord.
What was the time taken by the bank?
My Lord,
detect that
when
error?
my Lord, the locks of the
2001 to
pen.
2018.
Yes, my
About,
Lord. When the
17
locks
year-
of the pensioner was there, my Lord, that
You have
only
taken 17 years time.
So even in Daniel case it is
8 or
written.
18
With
Milord, 10
short-
years
short
Milord.
Huh?
span of
10
time.
years Milord.
8 years.
Yes Milord.
8 year.
So, Milord, the Constitution bench judgment is that is 1959 of the Supreme Court says, Milord, any payment has been made that may be recovered under Article
Yes, take up this matter to Supreme Court.
under
we are
section
bound by
under
Daniel
section 72 of the Contract Act, Milord, any mistakes payment has been given, neither waiver nor equity is applicable in this case, Milord.
Yes,
Lordship
yes.
may
All those things have been diluted by the latest apex court decision. We are bound by latest decision.
Well, my
Even
humble-
for that, I will cite a decision.
My humble submission, the latest decision between Milord the employer and employee. My case is that Milord the excess credit has been made.
All
Milord.
right, sir, you are not an employer.
I'm not
Correct.
employer, Milord.
Yes,
The
we will
excess
deal-
credit due to
we'll
mistakes
deal
which
with
has
that.
given, Milord, excess credit which is by mistakes which has given, Milord, the Supreme Court says if there is no any statute, section 72 is a contract that is applicable, Milord. The Constitution bench judgment, if Lordship permit me, Milord, so I will read 2 or 3 paragraphs, Milord.
Not necessary.
And Milord, the Chandi Prasad Unyal case, Milord, in itself says that the Sahib.
Sir, all those things have been diluted in the Rafiq Masai case.
No,
That,
Milord,
that has been referred.
My humble submission that, Milord, the Rafiq Masai case is also, Milord, certain direction has been laid down. That is come under the Article 142, Milord. What said, Milord, Your Lordship, at least one paragraph Unyal case, Milord, just I am referring, Milord.
No, you have
2000.
to give the list of citation. You can't go on citing something.
No, I have given, Milord, list of citation I am
Where is
given.
the citation, list of citation?
Kitab.
When did you give?
Books.
When did you give?
Milord, at 10:25, Milord.
If you give like this, how
No.
to assess
No,
the
certain,
book and all?
the book is there, Milord. Book has come, Milord. I have given the list of books, Milord, only. The book is there, Milord. If Lordship permit, Milord, that the 2012 8 SCC, Milord. Just I am referring, Milord. Paragraph 14, Milord. Page 417, Milord. Paragraph 14, Milord. May I read, Milord? We are concerned with the excess payment of public money which is often described as...
This judgment has been taken note of in the Rafiq Masai case. Or
Milord, taken note, not discussed, Milord.
Then go to Supreme Court.
Taken note, Milord, but it has
Then
not
go
been
to
discussed,
Supreme
Milord. That Supreme Court in Rafiq Masai case, when the matter was
Sir,
referred to
sorry,
the
sir.
larger bench, Milord,
Sorry,
said that
we will not appreciate. We are not going to distinguish with the Supreme Court decision. If there is any conflicting judgment, you have to rectify in the Supreme Court.
Milord, the Constitution bench judgment may
Please.
refer. 59 Supreme Court, Milord, paragraph 135.
This has not been taken note of by the Supreme Court in
Not
any
taken.
of the case.
Not taken, Milord.
Then you to go to the Supreme Court. Paragraph.
Paragraph, Milord, 24, Milord.
Read.
We are the opinion that the interpretation put by the Lordship to the Privy Council, so 72, section 72 is correct. There is no warrant of ascribing any limited meaning of the word mistake, as has been used certain that it is wide enough to cover not only the mistakes of fact but also mistakes of law. There is no conflict between the provision of section 72 of the one hand and the sections of 21, 22 of the Indian Contract Act on the other hand. The true principle enunciated is that one party under mistakes, whether of fact or law, pays to another party money which is not due by the contract or otherwise that money must be repaid. This mistake lies to think that the money paid was due to when in fact that it was not due, and that mistake, if established, entitled the party paying the money is recovered it back from the party receiving the same. The learned additional solicitors, Milord, they come to the Milord, to paragraph 29, Milord. In this, what happened in this case, Milord, the sales tax has been payment to the Milord by the SSC. After that, Milord, the law was amended, Milord. He filed the recovery application, Milord.
Yes.
Milord, the paragraph 31. We do not agree with that observation of Nagpur High Court. No such equitable consideration can be imported when the terms of Section 72 of the Indian Contract are clear and ambiguous. We may in this context refer to observation of the Lordship of the Privy Council so and so. In dealing with the argument which was urged there in regard to the minor contract which were declared to void is that one who seeks equity must do equity, and that the manner against whom the contract was declared void must refund the advantage which he has got out of the same. Their Lordship observed that the argument did not require further notice except by referring to a recent decision of this court in so and so. Paragraph. The ratio was applied by their Lordship of the fact that the case before them and the contention was negativity merely because the estate of UP had not retained the money paid by the respondent but had spent them away in the ordinary course of the business of the estate would not make the difference to the position, and under the plain terms of Section 72 of the Indian contract that the respondent would be entitled to recover back the money paid by it if the estate of UP under mistake of law.
Excess payment made during which period?
2008, Milord.
2008 or 2001 to 2018?
2018, Milord. 8 to 2018.
2005, the husband died.
Yes.
The
No,
payment,
on 1/9/2001 he has died. He has died on 1/9/2001. So from the October 2001,
Milord,
the respondent is entitled to family pension.
Yes.
Now from 2001 to 2018 there is a excess payment or
Full pension has been credited in his account, Milord, by
correct,
mistake.
from 2001 to 2018.
Yes, Milord. 2008 to 2018, Milord.
2008
to 2018. That is the, Milord.
Then between 2001 to 2008 what happened? Because the deceased employee died on 1/9/2001.
he retired on this that day.
Huh?
Retired on that day.
Died on?
Died on this year. In 2005.
Please give the
One-
date.
one to-
Where deceased employee retired on what date?
31st of
Just a
August.
minute.
31st of
August.
August 2001.
1.
He died on
1st of February 2005.
Supernated on 31/8/2001, Milord.
Yes, take them.
And he has died on 1/2/2005, Milord.
In the instant appeal, appellant, bank have questioned the validity of the learned single judge order dated so and so, passed in writ petition number so and so. Full stop. The respondent is legal heir of the deceased employee. Later Ram Nand Prasad. Full stop. The deceased Ram Nand Prasad while working in the Ministry of Mines, Government of India, attained age of superannuation and retired from service on 31/8/2001. Full stop. He died on 1/2/2005.
May I consider one thing, Lord? The division bench judgment also of this honorable court,
Please
Milord.
don't disturb while dictating. He died on 1/2/2005. Full stop. In this background, respondent Akhileshwari Devi, wife of deceased Ramnand Prasad, was entitled to family pension. Full stop. The family pension and family pension payment is arranged by the respective government through the nationalized bank Full stop. In the present case, pension payment was made to the deceased Ramnand Prasad was through the State Bank of India of its branch Shahajitpur branch. Full stop. The respondent bank, the appellant bank proceeded to remit pension of the deceased Ramnand Prasad as if he was alive even after 1/2/2005 and keep on remitting pension amount in his account. Till what day? What is the date of identifying the defect?
2018, my lord.
Correct, sir. What is the date?
Date, my lord, just
1/2/2018.
yes, my lord.
On 1/2/2018, appellant bank noticed that despite the fact that deceased Ramnand Prasad died on 1/2/2005, full pension is being remitted in favor of Ramnand Prasad from 1/2/2005 to 1/2/2018. First up, in this backdrop, the bank proceeded to order for recovery of excess payment made to the excess payment remitted in the deceased bank account and further proceeded to order recovery from the wife of the deceased Ramnand Prasad, namely Akhileshwari. Stated to have been paid to the deceased Ramnand Prasad is a sum of rupees 7,65,207. Thus, an order has been passed in respect of recovery of the aforesaid amount on monthly installment at rupees 5,000 per month. In the light of the aforesaid decision of the bank, respondent Akhileshwari Devi questioned the action of the appellant bank in CWJC 4156 of 2018. The learned single judge allowed the petition with reference to various decisions of the apex court, including the Rafiq Masai case, and held that recovery amount shall not be excess payment made in favor of the deceased Ramnand Prasad cannot be recovered from his wife, respondent Akhileshwari Devi. Feeling aggrieved and dissatisfied with the order of the learned single judge dated 1/7/2019 passed in CWJC 4156 of 2018, appellant bank presented this petition, presented this appeal. Next, learned counsel for the appellant vehemently submitted that writ court has no jurisdiction since a respondent husband, deceased Ramnand Prasad, was a central government employee. Therefore, she has to approach the Central Administrative Tribunal under Section 19 of the Administrative Tribunal Act in respect of questioning the recovery action by the appellant bank. The same has not been considered by the learned single judge. Full stop. Next paragraph. It is further submitted that due to error committed by the bank officials and not noticing that deceased Ramnand Prasad died on 31/8/2001, 1/2/2005. It is only a bona fide mistake in not noticing that deceased employee died on 1/2/2005 and proceeded to remit a full pension in his account from 1/2/2005 to 1/2/2018. Therefore, it is only a sheer mistake which could be rectified by the respondent appellant bank and ordered for recovery of excess payment made in favor of Ramnand Prasad from his wife Akhileshwari Devi dash respondent. Full stop. In support of the aforesaid contention, learned counsel for the appellant cited Apex Court has taken note of some of the recovery of excess payment the latest being the Thomas Daniel versus State of Kerala and others, passed in civil appeal number 7115 of 2010, decided on 2nd May 2022, reported in 2022 live law within bracket SC 438. Full stop. Learned counsel for the appellant submitted that Apex Court has not taken note of Constitution Bench decision of the Apex Court reported in 1950 AR 1959. Sales tax officer versus Kanhaiya Lal, page 135. Kanhaiya Lal Makund Lal Sharaf, para 24 31. Full stop. In the light of these facts and circumstances, the learned single judge order is to be set aside while upholding the order of recovery from the respondent Akhileshwari Devi, who is to heard the learned counsel for the appellant bank. Undisputed facts are that deceased employee Ramnand Prasad retired from the Ministry of Mines on 31/8/2001 and he died on 1/2/2005. Full stop. The appellant bank the deceased employee Ramnand Prasad was getting pension through the appellant bank from 1st September 2001 onwards. Full stop. The appellant bank, by oversight, remitted full pension even after the death of the deceased employee Ramnand Prasad on 1/2/2005 till 1/2/2018. Full stop. In the guise of rectifying the error committed by the appellant bank, the appellant bank calculated excess payment made in favor of the deceased Ramnand Prasad and arrived at a sum of rupees 7,65,207. Further, such recovery is on monthly installment at rupees 5,000 per month was ordered. Full stop. Next paragraph. The contention of the Land Council for the appellant that writ court has no jurisdiction in respect of challenge to the appellant bank's action insofar as recovery of excess payment made to the deceased Ramnand Prasad from his wife Akhileshwari Devi dash respondent herein, on the count that deceased Ramnand Prasad was a government servant. Therefore, a remedy for respondent Akhileshwari Devi was to invoke section 19 of the Administrative Tribunal Act and approach a jurisdictional administrative tribunal, and not invoking jurisdiction of this court under Article 226 of the Constitution. Full stop. The aforesaid contention cannot be appreciated for the reasons that deceased employee died on 1/2/2005. Therefore, master and servant relationship between deceased employee and Government of India ceases. Full stop. Further, the respondent Akhileshwari Devi has not questioned any action of the government / department so as to contend that she has a remedy before the administrative tribunal in respect of service condition of the deceased employee, service condition of a government servant. Full stop. In the present case, the appellant bank is not a government, and so also Akhileshwari Devi is not a government servant. Therefore, it is a purely not related to any service condition of the deceased employee. Full stop. Moreover, the action of the bank is subject matter. Full stop. Action taken by the appellant bank cannot be questioned before the administrative tribunal. In the light of these facts and circumstances, preliminary objection raised by the appellant bank in respect of maintainability of a writ petition stands rejected. Full stop. Next paragraph. Payment of excess amount, that is full pension, to the deceased in the name of deceased Ramnand Prasad, even after his death from 1/2/2005 till 1/2/2018, is due to sheer mistake. Full stop. At the same time, one has to take note of the fact that the appellant bank have noticed after 13 years from the date of death of the deceased
10 years, my lord.
deceased governments.
My lord, 10 years here is, my lord. The August 2008, my lord, the
8
was-
years.
10 years, my lord.
8
Art.
years, sir. 8
Yes,
years.
8 years.
After death of Ramnand Prasad, we stop. The appellant bank should have noticed payment of excess amount on in the year 2002 for the reasons that government of India has a policy decision that in respect of a retired employee who is earning a pension is required to furnish a live certificate every year in a particular month so as to extend a pension to such person who has attained age of superannuation and retired from service. To stop. The appellant bank have not obtained live certificate from the deceased Ramnand Prasad from 2005 to 2018. Full stop. This is a serious lapse on the part of the officials of the appellant bank in not obtaining live certificate from the pensioner from 2005 to 2018. Full stop. Further, if the excess payment is made in favor of the deceased Ramnand Prasad, the same cannot be recovered from his wife Akhileshwari Devi, who is a family pensioner. Full stop. Next paragraph. The cited decision do not assist the appellant for the reasons that the Constitution Bench decision cited supra para 24 and 31 reads as under. The aforesaid issue is relating to other than the pension matter. To stop. Apex Court time and again have come to the rendered a decision that if any excess payment made due to error, the same cannot be recovered unless an employee has misrepresented its employer to stop. The aforesaid principle is not applicable in the present case. To stop. The appellant bank have committed glaring error in not obtaining live certificate of the pensioner from 1 to 2005 to 2018. 1 to 2018. Further, the bank is conducting audit on a yearly basis. In such an audit, the appellant bank must have noticed what was the pension amount, pension/family pension is remitted by the concerned government in the appellant bank during the period from 1 to 2005 to 1 to 2018. The officials of the appellant bank have also not noticed that in the audit, the amount remitted by the concerned government is not tallying with the amount disbursed by the appellant bank to stop. If it is a case of 1 year, one could understand that there is a error or a mistake and it could be rectified. On the other hand, from 1 to 2005 to 1 to 2018, for these many years, the appellants have not taken note of the error committed by the officials of the bank. In the light of these facts and circumstances, the appellants have not made out a case accordingly. Appeal stands dismissed while confirming the order of the single judge.